This is our panel on algorithmic recruitment and employment. We are joined today by Aisling Kelly-Leith, who is a barrister at Blackstone Chambers. Practice includes both data protection and employment law. We're also joined by Halifam Abraha, who is an assistant professor at the International and European Law Department of the Utrecht School of Law. And on Zoom, hopefully, we also have Lindsay Zulaga, who is Dr. Lindsay Zulaga, who is a chief data scientist at HireVue, where she leads the development of AI-driven hire solutions that prioritize skill validation and job matching over traditional methods. I am Declan McDowell-Naylor. I'm a principal policy advisor at the Information Commissioner's Office, which is the data protection authority in the UK, in AI policy. I'll be moderating today's panel. So I just wanted to begin by giving all of the panelists an opportunity to set the scene a little bit with the work that they do in this area, why their work is relevant, etc. So I will, in the running order, pass first to you, Aisling, if that's okay.
Thanks, Declan. Great to see such a good turnout, as Declan said, for the last day today. I'm Aisling. I'm a barrister in the UK, so for those for whom that's not a familiar concept, I'm basically a freelance litigation lawyer, and I work on data protection law, tech regulation, employment, and lately I've also been doing quite a lot of competition antitrust law, and a lot of those cases nowadays relate to big technology companies, and I work for both claimants and defendants in those cases. So I want to make a starter contribution from my experience as a practitioner, because I think today we're going to be talking a good bit about the substantive law and the gaps in the substantive law. But the starting point I'd make is we actually have quite a lot of substantive law in the EU at least, particularly in the equality law realm. We have quite good law against discriminatory practices, including discriminatory algorithms. We also have the GDPR, of course, which has its shortcomings, which no doubt we'll come on to, but I think is a great starting point. But I wanted to bring the perspective of how that translates into practice, because we have the data protection authorities like the ICO. We know how much work they perform, but we also know how much work there is to do. And I think there's a bit of a challenge in empowering individuals, in particular individual workers, to hold employers to account. And there are a couple of key issues I wanted to raise. The first is how employees are supposed to get the evidence to bring their employers to court. So, for example, if a worker suspects that their employer is using a discriminatory algorithm to decide who to promote, how do they actually get the evidence to prove a prima facie case in a court? We've very recently seen a group of litigants in the US bringing a claim against Workday, alleging that their recruitment algorithm is discriminating against older workers. But the only way that that small group of litigants were able to do that was by lodging hundreds of job applications, sometimes at midnight, and showing that they got a refusal at 1 a.m. and arguing this surely can't be because of a human. Now, if you're an employee and you've not been promoted, you're not going to have that massive evidence to hand. So how are employees supposed to get the evidence to actually go to court? And secondly, even if they were able to get that evidence, what are the procedural mechanisms that enable employees to actually go to court? Because very few existing employees will want to bring their employer to court during the course of their employment relationship. But at the same time, there's quite little scope for collective action. So Article 80 sub 2, which enables member states of the GDPR, which enables member states to permit non-mandated collective action, so permits a non-profit organisation to bring an action without a mandate, hasn't really been implemented. In the UK, we've inherited the GDPR, but we haven't really seen any opt-out class actions because our procedural rules don't permit opt-out data protection class actions. So what we've actually seen in my experience as a competition litigator is data protection claims being shoehorned into competition law claims, which is great for consumers if it can work, but is not an avenue for employees because you can't really express a data protection infringement in the employment context as a competition violation. So I think we need to focus not only on the gaps in the substantive law, but also the procedural shortcomings that make it difficult to enforce in practice.
Thank you very much. pass to you, Halafon.
Thank you. Thank you very much. Thank you for joining us. My name is Halafon Abraha. I'm an assistant professor at Utrecht University in the Netherlands. My teaching and research expertise focus on digital rights and specifically on workers' data rights. I have been researching this area for the last 3-4 years. And I just completed a comprehensive research for the ILO, mapping the regulatory framework from multiple jurisdictions, identifying the gaps in the laws, including data protection law, AI regulation, labor laws, equality law, and other areas of law, and also exploring some potential pathways going forward. So today, I'll try to share with you some of the findings and my views about this, and looking forward to the discussion. Thank you.
Thank you very much. And then could we bring Lindsay onto the screen?
Yeah,
Oh, there
can you
you
hear
are.
me
Perfect.
okay?
Excellent.
Okay.
Yes, you're coming through very well. Thank you.
Hi. Hey, everyone, and good morning from Salt Lake City. Pleasure to be here. So I'm Lindsay Zulaga. I'm the Chief Data Scientist with HireVue, as was mentioned. HireVue is a video interviewing company originally. We kind of invented this idea 20 years ago of taking an asynchronous video interview. And in the years since have added a lot of different functionality to assess candidates, engage them in the process and get them through the hiring process. And a lot of that includes automation and some of that includes AI. So I come actually from a physics background, like a lot of people in data science that are my age. There was not a data science degree, and come from various STEM fields. So I was in academia for years, and then when I transitioned to industry, I actually had my own experience with hiring and kind of how horrible it is from a candidate's perspective to apply to jobs, and often feel like it's a black hole of you put in all this work and then don't hear anything back. And so I kind of got interested in hiring and how what the status quo was and kind of the problems with it, and obviously a lot of the biases that have been studied for a long time. So when I found HireVue, that was something really interesting to me, to kind of take this organizational psychology field of like, how do you assess talent and how do you understand what's important for a job and assess candidates properly and fairly, and bringing in a lot of the newer mathematical and computational techniques that we now have. So HireVue was really a pioneer in this space of using AI in hiring. And I think in a lot of ways, that put us in a position of being scrutinized a lot. So a lot of questions. I've been with HireVue for over 8 years, and in the early days the conversation was very different. There's a lot of confusion around what we were doing and a lot of fear. And so, a big part of my role has been to try to communicate what we're doing. And with time, what we've seen is more and more transparency has been better for us in every way, right? People used to kind of assume the worst about these technologies. And so kind of, how do we make sure we're communicating what we're doing exactly and make that that kind of an open, transparent system. We actually just had a paper come out in the MIS quarterly review with some academics who did a case study on this. It takes a long time to get a paper out, so it's a little older information, but it's about that journey a little bit, how we as a company opened up more and more, because we wanted to, share with the world and share with our candidates and our customers what we're actually doing to kind of ease concerns. So one of those things that we've done, or a couple things, are third-party audits that we've done voluntarily, so I have some experience there. That's kind of interesting because we started doing that 5 years ago, and it's still not very well defined. What is an AI audit? What does that mean? We have a lot more standards in the employment context, especially in the US, that we know kind of these are the statistics and the 4/5 rule and things like that. But no one really has a clearly defined like AI audit, and a lot of new laws are asking for things like that. we did an explainability statement with a firm in the UK, Best Practice AI, which we had some vetting or review by the ICO as well. So we've been fairly ready for a lot of the regulatory discussions that are, happening, and keeping up with that is a lot, especially here in the States. Although we have, just as of yesterday, a bill signed that could block all state AI regulation for 10 years. It's hard to imagine that going through, but it is pretty unprecedented to do something like that, because we also are probably not going to get any federal guidance on that. So a lot of what we think about is, yes, we have to keep up with, we're a global company, we have to keep up with all the laws that are being formed around the world, but we do look to the EU for a lot of that. Obviously, it's going to be the leader and kind of setting the stage, and there will be a lot of copycats of what is being done there, and kind of and like I said, we feel like we've been pretty prepared for a lot of this stuff because of the internal things that we've done kind of leading up to this point. So yeah, happy to talk more. I have a different background than the other panel members for sure, but I think we have a really good mix, so I can kind of speak to the in the wild and the vendor side of things.
Thank you, Lindsay. Yes, as you say, very good to have a mix of panelists today. And I think one of the things that we discussed previously was being able to draw out the international comparison, which I think you were getting at there with the various different laws in the US compared to the EU, etc. You also mentioned definitions. So one of the things, now we've kind of set the scene about who everyone is on this panel, one of the things we wanted to do initially was to also lay down some definitions to give some clarification to the debate. So setting out our panelists a kind of definition of algorithmic management and algorithmic hiring we felt would be quite useful to the audience, so we know we're kind of speaking on common terms here. So if I may go around the panel again, Ashlyn, starting with you, could you provide a sort of what your working definition of algorithmic hiring is and algorithmic management as well?
Yeah, so I think it's really interesting because obviously the issues that arise at the recruitment stage might be slightly different than those that arise during the employment relationship. But for my part, I think it's good to have quite a broad definition. So the Platform Worker Directive, which some of you may be familiar with, I think provides a really helpful definitional starting point. So it includes both algorithmic monitoring systems, so systems that are used to support monitoring, supervising, evaluating work performance, and then also automated decision-making systems. And these are systems that take or support, and I think that or support is really important because of the vagueness we've had with Article 22 of the GDPR, which we'll probably come on to. So which take or support decisions that significantly affect persons performing work. In the Platform Worker Directive, it's platform work. And then in particular respect, so with their working conditions, with their access to work assignments, their pay, their health and safety, working time, and also recruitment. So I think it's helpful to include a lot of different aspects in automated decision-making systems and algorithmic monitoring so that we capture that kind of broad house, and perhaps through a particularization or expansion of Article 22 of the GDPR. That's how I would approach it.
Okay, thank you. That's very helpful. Good to kind of get an idea that there's a broader definition in your mind of all of this. Okay, brilliant. Alfon, would you like to elaborate? Or
okay. I would also follow the Platform Directive definition. So the Platform Directive has two categories. That is automated decision-making or algorithmic management and automated monitoring. So I think that classification is helpful. So automated monitoring refers to any technology that is used for evaluation and monitoring of workers and work activities in the working environment, and which includes or which ranges from any traditional time tracking software to CCTV to more complex biometric systems and so on. Algorithmic management, for me, in simple terms, is the delegation of managerial tasks to an algorithm. It's the delegation of managerial decisions or tasks fully or partially to an algorithmic system that ranges from hiring to firing and everything in between. Having said that, I would like to add some caveats here. The two classifications in the Platform Directive, automated monitoring and algorithm management doesn't suggest that they are mutually exclusive. They actually reinforce and complement each other. For example, data collected in the monitoring process or surveillance are often fed into the algorithmic system. So algorithmic management presupposes some sort of monitoring, whether it is a traditional method of monitoring or more sophisticated AI-based monitoring.
Thank you. Good to get an understanding where you're coming from as well. Lindsay, if you may, would you like to also add a definition?
Yeah, I love everything that was said, and I think, and to the point of, yeah, the monitoring is the piece of gathering the data, right? And I think from kind of, maybe I'll say a little from the data science and the hiring perspective, I think what we've seen a lot is that when people talk about algorithms, often what they mean is machine learning. And if you actually look at, the definition of an algorithm, it may or may not be that. It may or may not be AI, right? Which when people say AI, usually what they mean is machine learning. It's a system that's learned rules from data, and it's fit that data to some mathematical function, and it can use that to make predictions. But algorithms can be very simple. You can have an algorithm about how to bake a cake or something like that. It's a set of rules. So I think it is important to kind of, when we talk about these legal definitions, it can get very tricky. And we've seen laws in the States where they're trying to define, this is some statistical process where you're doing machine learning and making a prediction versus, and often leaving out simpler algorithms that can be just as harmful. So that's something that we've brought into discussion quite a bit, because there, in hiring, for example, are some bad algorithms that are just older and they're not machine learning, but it's like a person said, if you have this term in your resume, then you can move on to the next stage. Or, maybe you did machine learning and you found people who have certain terms in their resume did well at this job, and then you have a lot of bias because maybe you hired only men in the past, which I'm sure everyone's heard these stories. But I think when we talk about algorithms, it's important to kind of differentiate. There's a lot of automation that can be quite simple, that can also be problematic, and there's also machine learning algorithms, and there's particularly things that rely on neural networks that can be really hard to explain. So a lot of the language models, the generative language models that are now coming online, they're interesting because they can actually explain themselves in words pretty well, but what's going on inside is very mysterious. So there are different levels of kind of of algorithmic opaqueness that have to be considered as well.
Thank you very much. So we're effectively working in this panel then, our team's in some agreement around a broad definition, but one that is also differentiated along the lines of, there's AI, there's algorithms, there's other kind of more sophisticated types of algorithms and machine learning, but to make sure that we are making those distinctions, I think is really, really important for us, especially given nowadays AI seems to be everything and anything. So good to have that distinction. I'm going to turn now to a set of more specific questions, leading into some questions around Article 22. But just to start with, I'm going to get the panel's thoughts, and again, I'll follow the same kind of order of speaker. Ashlyn, can algorithmic management of workers be effective and fair?
Easy question. So as we've kind of been discussing what the definition is of algorithmic management, we're talking about automating or semi-automating the managerial prerogative or managerial tasks. So do we think that can be effective and fair? I think that the answer to that has to be really context dependent, and I think it has to also be relative. So I would say that if an algorithm is well designed, sensitively deployed, it might end up being fairer and more effective than the human who might have been doing that managerial task before. And I say that because I don't think we should always imagine human decision-making to be some kind of gold standard in every case. A lot of people in this room are probably familiar with the book Noise by Cass Sunstein and Daniel Kahneman and Olivier Souvigny. And that book identifies the huge variance in human decision-making based on totally arbitrary factors. So to give you a couple of examples from that book, college admission officers were more likely to focus on academic credentials on a cloudy day and non-academic credentials on a sunny day. And a quarter of the time, recruiters disagreed, two recruiters sitting on the same panel disagreed about who they should hire. So you can imagine that if just one of those recruiters was the one sifting the CVs, that wouldn't necessarily lead to a unanimously positive decision. And then, of course, we have the perennial issue of human bias. There are plenty of meta-analyses of recruitment bias experiments. Often these consist of identical applications being sent out to employers with just indicators of protected characteristics being changed. And meta-analyses show systemically different outcomes for particular ethnic groups, for older applicants, for applicants with disabilities. So humans are not perfect. And I think there is scope for algorithmically supported decision-making to correct some of these errors, at least to some degree, if done well. I'll give one more example of why I think inserting a human in the loop is not always a positive impact. There was a really interesting paper in 2019 called "If You Give a Judge a Risk Score." And what it did is looked at judges in Kentucky and how they dealt with risk scores for defendants. And obviously the context for this is that risk scores, algorithmic risk scores for defendants, have previously been shown to be biased in various respects, particularly racially biased. But this paper showed that the judges in Kentucky were not more likely to make fair outcomes if given a relatively fairer algorithmic score. In fact, the judges varied in their reliance on the algorithm depending on the defendant's race. So the judges were more likely to override the recommendation of moderate risk for a black defendant than they were more likely to accept that risk score if it was a white defendant. So actually the human in that case was making the situation worse. So I'll make a couple of final points. I think fairness is quite an open textured concept. So I've just given some instances where we can say, humans are not perfect, and we might therefore say, well, perhaps the algorithm can be fairer. But we then have this more fundamental philosophical question of, do we actually want this system to be automated? Are we okay with losing human agency over this decision, even if we think it might lead to a fairer outcome? And as to effectiveness, I think we need to ask, in this context, what is effective? If you have a cancer screening algorithm and it's better than a human at detecting cancer, you might be able to say, okay, it's more effective. But if you're saying that this algorithm is accurate in identifying a good employee, what does that really mean? It depends entirely on the subjective concept of good. So if you're saying, well, they're a good employee because they're a good culture fit, but your culture is defined by a particular majority group, can you really say, okay, the algorithm is effective in identifying good employees? It really depends on what you mean by good. So I think that this idea of, is it fair, is it effective, it really has to depend on what we're comparing it to.
Thank you. Very comprehensive and detailed answer. Thank you very much. Halifam?
Nice. Okay. I would like to reflect on the fairness aspect of the question, but the effective aspect is something maybe more practical.
Mm-hmm.
So one of the often declared advantages or declared promises of algorithmic management in the workplace is that they can reduce bias and they can strengthen fairness. I think they claim that algorithmic management are neutral and fair by design is a long debunked myth. I don't think there is enough empirical evidence that algorithmic management can actually deliver on that promise. In fact, the reality is often the opposite. Algorithmic management systems raise serious concerns around fairness, around dignity, and workers' autonomy. So I don't think that algorithmic management can be fair by design. If, for example, the fairness issue can be raised at the design stage. If the leading scientists, data scientists and engineers who are leading the development of AI systems are predominantly from a certain age group or a certain gender group or cultural group, it's possible that the gender and cultural disparities could be built into the systems inadvertently. So the unfair AI systems could start at the design stage. There is also a fairness issue on the implementation stage. For example, it depends on several factors. For example, the purpose the AI system is used, or how it is used and the purpose it serves. So there are a lot of factors to consider. For example, do workers understand what is being monitored, or do they know the criteria used for algorithmic decision making? Do they understand or know the measurements made? For example, if algorithmic decision about workers is made using incomprehensive criteria or criteria that is not disclosed to the employees or workers, and criteria that is not clear, then we can speak about fairness. Can workers contest a decision? And is there a clear procedure for workers to enable them verify the decision and challenge if necessary? So it depends on a number of factors. Are the standards, for example, reasonable? If a pace is set by algorithm, it may not reflect the real capabilities or capacities of the workforce, and that will lead into stress and other health issues. So the answer to your question whether AI systems could be fair is it depends on a number of factors and how it is used and for what purpose.
Thank you. And I think also very useful as well to draw attention, as you did, to the difference between the development and the deployment of these tools, right? Which I think is a really important aspect because different people have different responsibilities for different parts of that whole process. Lindsay, I expect you want to make some points building on that. So if I'd like to pull you in here to respond.
Sure. Yeah, I'm glad, Aslan, you brought up the recidivism, like algorithms used in sentencing. Because, several years ago, there was this ProPublica article that kind of exposed this this tool called Compass that was being used in Florida, I believe, to show, hey, we looked at the data here and this algorithm's biased. And then the people who made the algorithm came back and said, that is not the definition of bias that we are using. And we were using this definition. So it's not false positives versus false positive rates for the two groups. We're using accuracy for, anyway, I won't get into it. There's like a few fundamental like fairness definitions, right? And they actually contradict one another. They all can't mutually be satisfied with most real world data. So this whole story spurred a debate, and there was several academic papers written about this to say mathematically, when you do have different base rates of recidivism among groups, which that's a whole other question as to why, right? Like the data could be biased in the first place because of treatment of different groups, but making an algorithm that satisfies every way of looking at fairness isn't actually possible with most, real data. So I think it's like a whole, issue right there is what does fairness actually mean? You can satisfy it. I mentioned the 4/5 rule in the United States, like for hiring. There's more to it than just that's just what it's called. And there's a bunch of statistics to figure out if you're scoring groups differently in a significant way, basically, right? But you could satisfy that and then fail miserably on well, in order to achieve that, we're punishing a certain group of high performers to get there. So this makes it much harder too when you think about regulation, because how do we even define that? In hiring, obviously, like this concept of adverse impact has been the way people have done things for a long time. It's basically looking at, what are the passing rates of different groups when they do an assessment, for example, or they ultimately when they get hired. And I do think, as I mentioned, like we've all seen the headlines about bias in, bias out. The data matters a lot and the design matters a lot. So doing this with care is really important. Algorithms are a powerful tool. They can be used for good or bad. It just depends what the data is and what the incentive is or the thing that you want to predict. So how are you balancing predicting some outcome like job performance or some sort of thing like turnover or whatever it may be with bias or like group differences. And for us, I think like a lot of the process is from industrial organizational psychology, or I believe in the EU they say organizational psychology, but it's really understanding the job well. First of all, what is this job? Like every job is different. What does it require? We don't want to ask anything. We don't want to ask candidates questions or have them do exercises or, games or whatever kind of assessment that is not related to this job. What are the things that are needed for this job? And I will say, even without algorithms even without AI or machine learning, there is a lot of gains you can get in making the hiring process more fair by just having standardization. Like the truth is, a lot of companies, they get hundreds or even thousands of applicants for one job. So the way that it works without any kind of automation or standard process is usually just random. Like we cannot possibly review all these people. So we're picking at random, or we're using some other way of picking that a human just came up with, like to see who we're going to evaluate and like move on to the next stage. So if you do have a process where you say, well, every single candidate has to go through this same thing to make it more fair, what you get is more diversity. And this is something we've seen time and time again. And I like to make it really clear, like this is not affirmative action. We're not like saying you get some bonus for being an underrepresented group. It's literally just, we want to look at things that are important to the job and take out some of that guesswork in the early stages of hiring. And what we get naturally is a lot more diverse of a group that kind of gets through the funnel. And you add to that AI, and there are a lot of really great mathematical techniques that can be added to that as well. So when you build the algorithm, you're incentivizing it to predict something, but you can do that while punishing it for having group differences on the outcome. So you're weighing different factors and saying, we want to blind the algorithm to things that tell us the person's gender or race. So if there was any hint to that, we don't want the algorithm to know that. So I think there's a lot of promise there as well. But yes, of course, my answer is this definitely can be done. And we see it in the data time and time again when we, give candidates the same kind of chance, and so we give them a standard process and we really measure what's important to the job, things like a virtual job tryout where you're doing activities that you would be doing on the job. Obviously, like what we get is people who are a better fit for the job, they stay longer in the job, they perform better in the job, and we can look at the statistics of who's being hired and see the needle move on diversity as well. And I'll add one more thing. In the US right now, or recently, there's been this kind of false dichotomy between merit and diversity. Like if you're doing diversity hiring, then you're not hiring the best person. And kind of what I just said with the data that we see really just proves that those things are mutually exclusive. If you implement a lot of standardization and job relevant steps in the process, you do get both merit and diversity.
Thank you very much, Lindsay. It's probably a good point to mention the ICO last year released a report based on a series of voluntary audits that we did with lots of AI and ADM in recruitment tool developers. And you can find that report on our website. It has something like 300 recommendations effectively for the sector. And we're continuing this work at the moment. We have a report coming out, some research that we've done with data subjects coming out soon. And interestingly, touching on what everyone has said here, one of the findings from that piece of research was a perception among data subjects that, at least in the early stages of a recruitment process that involves AI or automation, there is a perception that it can lead to increased fairness and less bias because of this kind of standardization approach that Lindsay was just mentioning. So that's just to mention something we've seen in some research that we commissioned. I'm going to move us now into the legislation and everyone's favourite area of the GDPR, Article 22. So I'm going to pose two questions. I know we have a running order, but in the interest of time, I'm going to fold our second and our fourth question together. So is Article 22 of the GDPR sufficient to protect workers from unfair AI-driven or algorithmic-driven employment practices? And in Lindsay's case, I think we discussed before, Lindsay, if you wanted to also make reference to some of the law in the US, that would be great too when you're answering the question. And then attached to that, depending on your answer, I suppose, do workers need new or different data rights in this area as well? So I will once again go around the panel and pose that question to you, Ashlyn. So Article 22, is it good? Do we need something else?
So for me, I think the biggest problem with Article 22 is its vagueness. At least that's my perspective as a practitioner. So, for example, we've been talking about automated screening out of job applicants. Does that fall within the remit of Article 22? From my perspective, it certainly seems likely that it does, because the Article 29 Working Party guidelines give denial of an employment opportunity as an example of a significant effect, which might trigger the provision. Also, Recital 71 in the GDPR refers to e-recruiting practices as an example. And then what about if you take a step back? So what if it's a score, an applicant score, which is then used by a human recruiter? Are we still within Article 22 territory? It seems like that's very likely to be possible following the Schufa judgment, especially if that score is very heavily relied upon at the decision stage. So assuming that we are within the scope of Article 22, we very quickly end up looking at the exceptions, and most obviously the contractual necessity exception. So then we have this, again, quite difficult and vague question of when is algorithmic management really necessary for entering into or performing a contract? So in the situation that Lindsay just mentioned, one can see that there might be scope for justification or for reliance on contractual necessity when the employer is receiving thousands of job applications and more than they could ever humanly process. But what about during the employment relationship? So is automated decision-making about working time contractually necessary? How do you really decide that? So I think the vagueness of Article 22, despite some recent court judgments starting to provide clarity, is its key vice, because if it's very strictly interpreted, it becomes quite quickly difficult to see compliance in practice happening. But then if you interpret it too broadly or too leniently, it becomes pretty ineffective. So for my part, I think we probably need particularization of the specific types of decision that are always prohibited. So I would include termination of the employment relationship in there. That's what the Platform Worker Directive does for platform workers, for example. And then I think we should look at other safeguards. So, for example, I think there should be a requirement of overarching human review if you have a CV screening algorithm, for example. And again, the Platform Worker Directive at Article 10 of that directive has a kind of participatory oversight, so a top-down approach in which worker representatives have to have some involvement, where they evaluate at least every 2 years the impacts of the algorithms that are in use. And then I also think, referring to what Halifam said about contestability, we should ensure that there's proper scope for human review if an important decision is made without human intervention. And particularly during the course of the employment relationship, it seems pretty obvious that that should be available. And again, I think the Platform Worker Directive provides a pretty good model for this at Article 11. But then on the second part of the question, do workers need different data rights? I actually wouldn't put this in with Article 22 necessarily. I think there are a couple of places where I would say new or different data rights are required, but not necessarily in the automated decision-making context. It actually goes back more to what I was saying at the beginning about the effectiveness in practice. So first of all, I think we need rights at the collective level. So the GDPR is very individualized. We have seen some clever uses of the individual rights. So for example, we've seen efforts by unions to get porting of data using the data portability rights so that it can be aggregated and analysed by the union. There's also scope for unions to be mandated under Article 80. But fundamentally, data is used by employers in the aggregate, and data subjects, qua workers, really only have access to their own data, which is not that helpful. So I think, again, if we go back to that idea of this participatory oversight, the evaluation of the impact of the algorithm, that's a way in which collective rights can be realised. So worker representatives being permitted that kind of access and that kind of control. And also, another great point about the Platform Worker Directive, and which I think should be expanded to worker data rights more generally, is that the representatives, when they do those evaluations, actually have a right to expert support if they need it, which the employer has to pay for. Now, it only applies if the employer is above a certain size, and the expert support has to be necessary. But given that we're talking, as Lindsay's been referring to, about very complex systems potentially, I think having these representative, expert-assisted evaluation procedures is quite important. And then the second point I'd make about new or different rights, and it's quite closely related, is transparency. Because as I mentioned before, workers can access their own data, they can exercise rights over their own data, but again, it doesn't really help when data is analysed and used in the aggregate. It's really valuable when it's aggregated. And we might come on to talk about transparency, but we have this right, when Article 22 applies, there's this kind of correlative right under Article 15 to get an explanation, but because that seems to be sort of tied into Article 22, there are cases where it won't arise. So generally, workers can't really hold their employers to account for decisions made based on aggregate data, whether it's discrimination, whether it's unfairness, unless they know what the results of the algorithms are. So we need to have some access for workers or their representatives to the results of the kind of audits that Lindsay's been mentioning, or at least to the data protection impact assessments, which there's no obligation to publish. And that, to me, is a kind of key gap, that collective access and the transparency, I would say.
Thank you very much. Halifon, would you like to?
Yeah, sure. Article 22. From the regulation of algorithm management perspective, I think the Article 22 of the GDPR is the most relevant and important protection we have so far, because the platform work does not apply to traditional working environment. It is important because it says that it should be humans, not algorithms, that should make high-stake decisions. For example, whether someone deserves a job. It should be made by humans, not by algorithms. So this is very important protection. And it provides a set of individual rights, like the right to obtain human intervention, the right to express one's point of view, the right to contest a decision, and the right to an explanation. The problem is all these rights depend on transparency and the contestability of the system. And Article 22 is problematic in this case because the problem comes from two directions. One is the vagueness, that is the way the provision is designed, and from the structural design of the GDPR itself. So I will come to the GDPR design problem, but to just focus on that provision, the protections and safeguards we have under Article 22 are subject to layers of exceptions and caveats that eventually weaken the efficacy of that provision. So it does not apply, all these rights that I just mentioned do not apply to all automated decisions. It applies only to significant decisions, and it's a challenge what constitutes a significant decision. For example, decisions that we may consider insignificant, when you consider them separately, may end up have a significant impact when they consider together. So what does it mean, significant impact? And that is the problem. So you can see how these problems could be fixed by looking how the platform directive is designed, reflecting on each and every rights and protections that are under Article 22, and it provides a targeted and refined, a tailored protection expanding on these rights. So that is one. To your second question, do we need new rights or new protections? So before addressing that question, let me highlight the regulatory deficiencies that we have today, or the challenges and shortcomings of existing regulatory frameworks. So what are we talking about when we talk about data protection in the workplace or algorithm management in the workplace? What does the relationship look like? The employment relationship is fundamentally different from the relationship that data protection law or the GDPR tries to address. There is a difference. Unfortunately, we are treating them the same. So data processing or algorithm management in the workplace is different from different factors. So I will highlight just two. The first one is the nature of the data collection process. Obviously, our daily private and public lives is being tracked, and our data is routinely collected. But it would be a misconception if we conceive that the continuous monitoring and surveillance in the workplace is a mere extension of this data collection. It is fundamentally different, characterized by persistent, inescapable, and routine data collection. Even every routine activity in the workplace entails a continuous observation of workers' behaviors, workers' activities through data. And you cannot escape this. It's not sporadic, it is not transactional, like we have in other contexts. So that is one challenge, that the continuous nature of data collection and observance of workers through data is the essential consequence of their employment relationship itself. So that's one. The second point is the relationship, the nature of the relationship itself. So under the GDPR, we have the relationship between the controller and the data subject. And the GDPR treats employment relationship the same, which is completely different. It's a different relationship. It's a relationship of power. Of course, the relationship of data subjects and data controllers is also involves a relationship of power, but the power we have, the power asymmetry we have in the employment relationship is fundamentally different. And that is not considered under data protection laws. So the power dynamics more much beyond that the traditional employee data protection or data subject and controller relationships. And for example, as consumers, we have a relative freedom to choose the type of service or the type of technology we want. We can choose the type of app we want to install to our devices. Workers do not have such luxury. They cannot escape from, they don't have the power to choose what type of technology that is being introduced to the workplace and how it's being used. So that is different. It is, the power dynamics is different, and data protection laws, including the GDPR, do not consider these points. Just to add something on that relationship, the employment relationship is also personal in nature. It's personal in nature, it's presumed to be built on mutual trust and confidence. And when you rely on algorithmic management systems, there is a potential to diminish that trust. For example, if you delegate managerial decisions to an algorithmic system, there is a risk of depersonalizing that personal nature of the relationship and then eventually eroding that trust. The problem is the laws we have today do not take these unique features of the employment relationship into account. So when we try to regulate algorithmic management or automatic decision making and surveillance in the workplace, we are running into a very complex overlap of multiple domains, legal domains, including labor law, equality law, data protection law, health and safety, and they are all have different objectives, different conceptions, and different philosophies. And when it comes to the EU, it's even worse. We have national laws and union laws that they do not read to each other. So let me highlight the overlap between labor law, that's very important, the labor law and the data protection law. So at the Article 22, working party highlight the data protection rules or data protection, data processing in the workplace does not operate in isolation from labor law and vice versa. So they necessarily overlap. And this has advantages and disadvantages. Labor law prioritizes collective solution. And it provides minimum standards that are not waivable, even with consent. So very important principles and non-waivable solutions at collective level. So the underlying principle for labor law is to rectify the power problem. That is not the case in the data protection law. So in labor law, even though it has these important principles, most, if not all, labor laws predate algorithmic management tools. So they don't provide enough protection to address some of the new risks that we see today. So data protection is important because the labor law is almost outdated in this case. Data protection plays a crucial role for a couple of reasons. One is because of the centrality of data in these decision-making processes. They rely on massive amount of data, so data protection is important. Data protection law is also important because it is the first instrument, the first regulatory tool or response to the risks posed by new technologies since the 70s. So data protection law has been in the front line to protect risks that come from new technologies. Having said that, the way data protection laws are designed are not appropriate for the workplace. One of the problems is that, for example, the GDPR, it treats employees as consumers or data subjects. And that is not how employment or labor laws see employees, or the relationship is different. So based on the GDPR, the relationship, it treats employment relationship the same way as the relationship we have with an app we install in our phone. And that is completely different. You can have the relative freedom to choose the type of service. That is not the case in employment.
Halafum, if I may,
Yeah,
it's a very, very comprehensive answer,
Thank
but I
you.
would like to give
Okay.
Lindsay the opportunity to speak and
Yeah.
also make sure we have questions. Sorry to interrupt.
Sure.
Lindsay, would you like to come in on this question now, if you don't mind? Or even
Sure.
as we discuss, possibly discuss US laws as well, would be very interesting, I think.
Yeah, I mean, we've seen a lot of the same challenges, Article 22 as things that are coming up in the US, which is kind of this gray area of deciding what does it mean to make a decision based solely, or what does decision support, or how much of the decision is this influencing? And there's a great book, it's almost 10 years old now, called Weapons of Math Destruction, by Kathy O'Neill, and she did an audit for us, which I think it kind of speaks to some of the other topics that came up around stakeholders and in this case, job candidates that there's this big power differential, right? And so how do you challenge, how do you even opting out, like as a candidate, I don't know what that means is going to happen to me. Is that going to hurt my chances? It could, very likely, you know, like it doesn't always mean I'm going to get a more fair shot. It means there could be thousands and thousands of people and I might not get evaluated. So a lot of this book is about algorithms gone wrong, right? And just high stakes decisions that were made. These were kind of the earlier days too, where we had some lessons to learn, things like firing teachers because of some, I mean, when you really look at the algorithm, anyone can see that it's a stupid algorithm, like it wasn't a very good way to make a decision, but people were trusting it because the algorithm said. And so I think we've come a long way since that time when that book was written, but really looking at all the stakeholders in the system, and that's how her audit worked, was, you know, how are candidates seeing this? How are the users seeing it? Who are all the different academics, lawmakers, like what are the concerns of all these different parties and how we kind of address those things? I think, you know, so because of that power differential, a big burden needs to fall on vendors and employers to design systems from the get-go that are auditable and explainable, and they can be challenged, and that, you know, take into account all these things, all this care around fairness, et cetera. But I will say there's also another, so in the US, we have one of the last couple of years, one of the biggest pieces of legislation was this New York City local law 144, which is specifically a hiring law around automated employment decision tools. And that law was widely criticized and really is pretty widely considered a flop because first it was written, it wasn't very clear. There was a lot of kind of back and forth and redefining. There's some fundamental elements that are very common in these kinds of laws, like you need to disclose that AI is being used, you need to do annual audits. The candidate can request the data and information like that was collected on them and analyzed, but it wasn't clear what an audit even means, right? And that got a little more clear. That got more clear towards the end, but there is no actually standards for the audit. This idea of just making people do the audit itself will be helpful, but there's no pass or fail of what the audit actually needs to do. And it's this question of like how many people can go read an adverse impact report that with a bunch of statistics and make any sense of that and know what it means. It's kind of specialized. There was an academic paper, I think last year, about the law, and they looked into like almost 400 New York City employers, and like 18 of them had published reports. So people there's really not a lot of enforcement. People aren't really doing anything about it. It was kind of hopefully a lesson learned in how not to do things. Now we have laws coming in California, Colorado is a big one, and it mirrors a lot of the EU AI Act with looking at impact assessments for like high risk systems. But again, it has these issues with, is it substantially contributing to making a decision? And it leaves a lot of wiggle room, like the New York City law, for companies to say that doesn't apply to me. And so I think that's going to be a big issue. I'll add just quickly, just looking at my notes. I think one issue here that a lot of people don't talk about when we talk about decisions and humans in the loop, it's, you know, all of our customers, they're making the final decision on who they're going to hire. Like our software is not designed to do that for you. It's designed to help you sort people and kind of focus your attention on the most promising candidates and then move forward with those candidates. However, a lot of it isn't discussed a lot, all the people that didn't get the job, right? And this kind of don't let the algorithm make a decision language means that there's incentive for companies to just never get back to people. So I think that's an interesting point to bring up, because if you don't make a decision, even if you essentially did, but you don't ever say you didn't get the job, then you're not making a decision. You just leave a bunch of people hanging, which is not great for the candidate experience either.
If I can just jump in on that, I think that's where the Schufa case law is really interesting, because in that case, the score is basically the decision, because if they're below a certain score and they're never going to get back to them, that is the decision. So the substantive law is there, and then it immediately goes back into this question I keep on harping on about of how does the applicant ever bring a claim or complain about anything if they never get an email saying you've been rejected, right? So I think it's an example of where the substantive law actually is there. We have the case law, but we don't have the enforcement mechanism.
Yeah, and how do you and for the companies, it's just like at the end of the day, they can't control how many people apply. I mean, they can close the job very quickly or whatever, but at the end of the day, like they are just faced with huge volumes of candidates, and so being able to, you know, kind of the human review, like you said, Eslin, is just not possible in a lot of these cases for every single candidate.
Can I just check how many questions there are in the audience? That's a few. Okay, so I think we might have to skip the explainability question, which is hopefully okay with everyone. Okay, several questions. I think the person over here seems to be the first hand to shoot up.
Thank you for this. I'm basically representing Serbuk University, and we are going to establish an alumni association in law and technology. And I have been hearing from my friends who are in their orientation year that applying jobs in Netherlands is becoming more and more hard because they are using applicant tracking systems, and most of them they get eliminated by different things that they don't know. And there is no standardization of it, and some of the candidates doesn't know about this applicant tracking system and what kind of algorithm is used against them. And the HR are throwing out different, very suggestions, even conflicting with themselves, saying that, okay, you should have one-page CV or two-page CV with like pictures, but the CVs with pictures are terrible with applicant tracking system, and you get eliminated at the end. Because of that, like the applying and getting a job ends up being a Hercules impossible task kind of thing, because you have to throw so many hula hoops and such. And most of the candidates, not most, but some of the candidates are actually considering using tactics like putting Google's $1 million of profit in white on white background, so that the like the ChatGPT or like the algorithm would understand, okay, this is not a loser. I should like bring them to the hire, so they could be like hired. And this is not how most of the candidates think their data will be processed fairly. How can we manage it? Like, how can we establish a feasible balancing GDPR-friendly approach here? Would there be some sort of like standardized templates of CVs that could be AI-friendly, also user-friendly as well, so they wouldn't be eliminated unfairly?
Okay, it's a practical question. My plea to the panelists is, could you keep your answers to around a minute, just so we have time to get everyone, and I suppose if there's any follow-up, then please obviously engage with people afterwards. Who would like to take this one? I think it seems maybe slightly in your direction, Lindsay. It's a question, I guess it's a practical question about implementation.
Yeah, it's a problem that's been around for a while, right? And the putting the white words in the back of your CV is something we've seen years ago. I would just say, yeah, it's tough for candidates because of this volume issue. And so it isn't always the automation or the AI that is, you know, a lot of time gets the blame, but really what it is back to the volume issue where 99.9% of the people didn't get the job. So there is sometimes a little bit of a, hey, I didn't get the job because of AI. AI may or may not have been used, but most people didn't get the job, and it's not fun to be a candidate and be applying for dozens and dozens of jobs and not hearing anything back and not knowing how you're getting evaluated. I would say, you know, a lot of these applicant tracking systems they're big clunky machines, and you know, we integrate with a lot of them, but they're often kind of used for compliance, and there's a lot of purposes they serve. A lot of them are still using bad algorithms, right? Like if you're looking for certain keywords in a resume, and people can game that, that's not as good of an assessment as like having someone do a virtual job tryout or having them, you know, showcase their skills. So I would say, yes, we're still struggling with a lot of this bad automation and kind of, you know, algorithms that aren't very good at predicting who would be at the job. I mean, looking at GPA is a great example. That was an easy way to filter people. It's actually not very predictive of success on the job.
Thank you. Is anything to add from the other panelists, or we have to take another question?
Maybe I can say something. So I didn't get your name, but it's a very important question. I think this is related to the issue of explainability. That so people apply for a job and get rejected. They do not know why. Recently, I attended a workshop where one of the researchers was reporting how even managers get confused about the algorithm management hiring tools. So even the managers calling to their suppliers saying, hey, the algorithm is giving warnings to my employees. That was not my intention. What do I do? So I think this is a problem. So if the employer cannot explain or justify AI-driven decision-making, this is a problem with the technology, not with the law, because the right to explanation is a fundamental right, as confirmed recently. So such systems should not be used in the first place. Employers should not use systems that they could not understand and explain to candidates.
Okay.
Two tiny points on to what Halfom's just said, because they rise in relation to this. I think there are two developments in EU law that might help with this. The first is, we haven't mentioned the AI Act yet, but as Halfom said, I think the current position is that lots of employers don't know how their algorithmic management tools work. Hopefully that will change with the technical documentation that has to be provided to deployers by providers. So that will be interesting to see if that's an improvement. And secondly, I think Halfom was alluding to the Dun & Bradstreet judgment of the Court of Justice, which basically says you need to be able to provide, if you have an Article 22 type decision, an understandable, meaningful explanation. And I think the corollary of that is if you can't provide such an explanation, as Halfom said, you can't deploy the system. So I think those two, the kind of the AI Act plus that new Court of Justice ruling, I'm hoping could provide a greater scope for employers to actually be able to explain to candidates, this is why you didn't get the job, and we'll then have a better understanding of whether those explanations make sense.
Very interesting. Can I take another question from, let's go with Tom.
Thanks, Tom West from Privacy International. Firstly, just to reflect on that point there, in the answer to your question of what else is missing, absolutely I agree there needs to be a right to explanations, and that those must be personalised. They can't just be sort of blanket, boilerplate explanations. My question is, can it ever be fair for a hiring algorithm to make a decision or to contribute to support a decision which is based on criteria which are not set out in the job advert?
Okay.
I think that's a great question.
Whoever wants to jump in,
I don't know.
go for it. Good question.
Yeah, I don't know of any. I actually haven't really heard anyone discussing that as a standard, which I think is really important. Job descriptions or job adverts are pretty widely known to be horrible. I mean, even as we look at that as a piece of valuable data, what is this job? What is the job about? And trying to cross-reference that with databases of jobs like the ONET from the US government is a great resource where it's defined many different jobs, what are required for that job, et cetera. But people usually just write job descriptions. And actually generative AI has probably helping with that more and more, but does it even match the actual job, and does it include all of the things, right? So I think it's a great question, and it's an area that's like ripe for improvement. How do you write a good job description? A lot of companies are just relying on whoever, the hiring manager, the recruiter is just kind of writing one, right? Without a lot of standardization. So to be really clear on this is, we have like a job analysis of what this job requires, and these are the things, that you're going to be measured on in an assessment, I think would be a great practice. As of now, we don't have a lot of control over those job adverts. It's kind of separate from what we do. And I think that's true for most vendors.
I suppose I would just add to that I don't know whether we've ever had, in human history, cases where the job description or the job criteria are the only things that are considered by an employer. I think from having researched algorithmic discrimination, the thing that struck me the most was how much implicit human discrimination is out there that we just haven't been able to eradicate through decades of equality law. So I actually think possibly a move towards a more technologically driven decision-making systems might enable us to try and get closer to that, but obviously that depends entirely on the types of systems we adopt. But I would say I don't think there's probably ever been a case of a person being employed for a job and there being no factor in the employer's mind other than the criteria. I think there's always going to be implicit factors that we don't even realize we're considering when we look at an application.
Halfom, anything to add?
I agree with Ashleen that the hiring process is rooted with implicit bias, and we take considerations that are not in the advert. But the problem with AI is it's supposed to reduce or address this problem, but if we use criteria that are not disclosed, we are actually systematizing this human implicit bias, and it is completely unfair for me. If a job candidate is rejected by AI-driven decision-making, the very basic they would expect is a clear explanation of why this happened. What are the criteria used for the decision-making? How it is each criteria influence the outcome, and it should be communicated before the decision-making, not after the fact. Otherwise, we are systematizing the implicit bias.
I think we have time for one more question. I think we haven't had the person with the bell yet, which is...
It's coming.
I'm disappointed. Yes, sorry, where are the questions in the room? Oh, already, okay. No, your prerogative. There's the bell. Thank you.
Before anything, thank you so much for the panel, very fruitful. My question would be on...
Thank you.
I was waiting for you.
Almost saved by the bell. My question would be on how to calibrate and develop standards on the role of the human review of automated decisions.
Okay. I love a succinct question. Thank you very much. Again, whoever would like to take that, please do.
In the work context, I think the platform work is a perfect legislation. It has 4 layers of transparency of human review. That's at an individual level, the collective level, for regulators, and for systemic review. So there are different layers of transparency and human involvement for different actors and for different purposes.
A succinct answer, even better. Thank you. Ashton, Lindsay, anything to add to that?
I completely agree with Halafam. I should say that prior to the Platform Worker Directive, we, both of us and some other colleagues, wrote a paper about what is missing for algorithmic management. And most of what we wanted ended up in the Platform Worker Directive. So that's why I think we both like it so much, because it realizes a lot of that kind of top-down review and review. But for me, it's the most important, as I said, was the collective top-down systematic review, which I think is really missing at the moment.
Lindsay, final word?
Yeah. Yeah, I'll just add quickly. I mean, I think for us, talking about human review, we know humans have a lot of bias, right? So a lot of times human review means come in and use your biases on this and hire the people you like or something like that. And so I think just getting at the spirit of the question without knowing about the platform stuff. But I think, you know, building tools to standardize that even more, and that's part of what we do without algorithms, but humans are making this decision. Humans are doing live interviews. Live interviews are a huge problem. Like they're unstructured a lot of times. How do we try to help structure those things and bring structure into the human interaction as well?
Brilliant. Thank you very much. Thank you all very much for attending. Nice to see so many people at this panel, especially on the last day. So very grateful for that. And thank you as well, of course, to the panel for some excellent contributions today. I'm sorry we didn't have more time for questions, but I think everything you said was very comprehensive and detailed and informative. So thank you very, very much. Thank you.